Hello and welcome to the first Lunch and Learn free webinar for Chamber members. Today's session is an introduction to employment law with presenter Tom Nation, partner of Timpany Walton. Tom will cover the Employment Relations Act, various types of employment arrangements, personal grievances and exit strategies, and managing leave to enhance your understanding and protect your business from legal risks. Just a few quick notes before we start. So all attendee cameras and microphones are turned off. The chat function is disabled for attendees. However, we do encourage you to ask questions. So this can be done through the Q&A button at the bottom of your screen. If Tom doesn't answer these throughout the session, I'll pop back and ask on your behalf at the end of the session. And lastly, a recording of this webinar will be sent out to attendees following the conclusion of this session. So now I would like to welcome Tom to discuss employment law with us. Thank you, Tom.
Thanks, Fiona. Oh, no. Stacey is here we go. I'm just going to share the right screen and it will all come together. There we go. So welcome everyone to this wonderful webinar that I'm sure will be a lovely way to spend your lunchtime and hopefully we can all get something out of it. So just a bit about me. I am the litigation partner here at Timpany Walton. So I head up a team of 4. Relevant for today, we do a lot of employment work. So that is acting for both employers and employees, predominantly employers, as we help them with processes, personal grievances, and that sort of thing. And then outside of that, we do a whole lot of other work that comes from that. So employment agreements and then debt collection, all that sort of stuff. If you've got any questions or anything like that, please feel free to reach out. So as Stacey said, we're going to sort of fly through a number of different topics: the Employment Relations Act, various types of employment, personal grievances, and managing leave. It's really important that this is only a 45-minute session. So this is going to be a really brief, I guess, overview rather than trying to give you all the answers because that would take significantly longer and would be probably a far more boring seminar, but this will just give you the highlights. So what ideally I'd like you all to be able to take away from here is going, all right, well, hold on. I know there's something here that I need to check or that I need to double check before you march off down the wrong path. So if you do have any questions, like I say, sing out throughout. There's the Q&A tab that I have open and we'll try and keep open as we go. I personally hate webinars because one of the things I love, if you've come to my training that I do for the Chamber from time to time, I do like the back and forth with people. So when it's just me talking to myself, I've got no idea whether you're enjoying it or finding it entirely miserable. So I will assume that I am hilarious and that this is a wonderful time and we're just going to box on. So the first thing that I always start any employment law seminar on is we sort of deal with the elephant in the room. Employment law sucks. It is really employee focused. It's not just about doing the right thing, but proving that you did the right thing. And what that means in reality is that what can be or seem like a really healthy process and a good process for running or how you want to deal with people isn't what actually has to happen. Instead of calling someone in and having a nice casual conversation, we're putting things in writing, setting things out, which means that it becomes quite formal and it's not how we're normally communicating with people. So that does make it tough. And one of the challenges we have as an employer or as a manager is deciding when you need to go from a formal process, so the classic disciplinary process that we'll talk about later on, as opposed to that informal chat of going, hey, look, what happened the other day wasn't quite what we're after here, or what this sort of thing. The big thing that I always stress to everyone is employment law is stressful, dealing with employees is stressful, personal relationships is stressful. So take time to think before you act. It is really hard to undo the damage when you've told someone basically, you're fired, don't come back, I never want to see you again. And we do still see that happen from time to time, and that's understandable, especially when times are tough for businesses, there's a lot of stress going on, but we do just take your time, make sure you've got your processes right, and then we can look to get in there and do that right. the big thing is your record keeping as well. So when we talk about your minimum entitlements, which we'll touch on later on, for your wages and that sort of thing, you need a good record keeping system where you've got all your notes, etc., or at least your wage and time records. That's not as much of an issue, I think, for most employers now, as we've all moved to sort of online or web-based or app-based payroll systems, computer-based. But if you're still running the old paper wage book, make sure that you've got a good backup somewhere and that you are filling it out, as that can be the challenge. So the starting point, whenever we think about employment law, is, funnily enough, the Employment Relations Act. There's a whole pile of legislation that governs employment law, and it is confusing. Some of those pieces of legislation are absolutely rubbish, like the Holidays Act. They are confusing and are in the process of being updated. When that happens, I don't know. It's apparently on the government's pipeline, and we'll see what happens there. There's the Labor government did start that process, but then, as always happens, the powers that be change and they have a different view of things. Hopefully it does, because it's not fit for purpose. But anyway, I'll get back on track. So the most important thing that comes out of the Employment Relations Act is an obligation for employers to deal with employees in good faith. And when we sort of distill that down, what that really means is that before you make a decision that impacts an employee, you've got to talk to the employee about it. And the employee has to have a real ability to have or to give comment on that. And so I've pulled this out of the Employment Relations Act. So what that means is good faith is it requires an employer who is proposing to make a decision that will or is likely to have an adverse effect on the continuation of the employment of one or more of the employees. They need to have access to the information relevant to that, and then an opportunity to comment on that information before the decision is made. So open book, let's give them the information so they can comment on it and do that. And if we follow that through into every little thing we have, whether it's a disciplinary process, performance management, changing the hours, a restructure, redundancy, all those sorts of things, this is what it comes back to. Kerry, look, I can absolutely send that presentation out so you can come back to it. It's a lot of what we're talking about today. It's the bullet points, and I'll be speaking to them, but I'll definitely get that sent out. So here we go. The other things that are throughout the Employment Relations Act is the rest of meal breaks. That's something that often gets glossed over, because when employment is going well, employment relationships are going well, no one really considers that. But unless you've put that in there in your employment agreement, then the defaults apply. There's a whole other range of things that can apply to various businesses. Things around the requirement to provide breastfeeding facilities and requests for flexible working. Some of these things apply differently to different businesses as well. So the obligations on an employer, I've seen some of the attendees here, the large employers, things like the council or say Fonterra, Sanfords, looking at those compared to a small 1 or 2 person employer business. Say, I think I saw Warren Leslie and Golf Stop on the list today. There's a different obligation on them and what that means, but it's just all encompassing there. The other key part of the Employment Relations Act that most employers now are using is the 90-day trial clause. I will go on about this till the day I die, or while at least it stays in legislation. The most important thing for people when you have your 90-day trial clause is that it needs to be clearly set out in your employment agreement. It needs to say that the period that it applies for, so 90 days, it doesn't say up to 90 days, it says 90 days. And it starts at the commencement of their employment. So if their first day of employment is 4 June, you say starting from 4 June for a period of 90 days. It will set out that the employer can dismiss the employee, and if the employer does that, the employee can't bring a personal grievance for the dismissal. What that doesn't prevent is a personal grievance for other things that may have gone on during the employment. And sometimes we see employers who have a default clause that puts a whole lot of obligations on them under the 90-day trial clause. says, well, and it's doing the sort of things that you want to do, where you might say, we're going to provide the employee with training or guidance or feedback on how they're performing. If you don't provide those things, then the employee could come back and say, look, I know you dismissed me. I can't do anything about the dismissal, but actually, you haven't done these things. So that's an unjustified action. You haven't done what you contracted to do. And so the employee can raise a grievance for that. We're seeing less and less of that these days, but it's just something to be conscious of. Most importantly, though, you've got this wonderful clause, you've got this wonderful employment agreement. That's great. But the employment agreement needs to be signed before they do any work for you whatsoever. So here at Timpany Walton, what we say, and we've never had to enforce this, but if someone hadn't signed their employment agreement before they started work, they wouldn't be allowed past the front desk saying, look, before you come here, before you start doing work, you're signing on the dotted line, because we know that we need that employment agreement signed. The other thing as well is that life gets busy, work gets busy, and we forget it. So if you don't sign that right at the start, what's going to happen is something will pop up, the phone will ring, etc., etc. 2 years down the track, something goes wrong, and you go, hey, look, I'll pull out that employment agreement. Oh, crap, I never got that signed. So it's a good thing. But we need that for your 90-day trial clause. We need that contract signed before they do any work for you whatsoever. The other key part here is that it's different to a probationary period. So saw that a bit when the rules were different around the number of employees that it could apply to. So a probation period is essentially putting the employee on notice that at the start of their employment, there'll be a period where they are on probation. That doesn't mean that they can be dismissed and that they can't bring a personal grievance in respect to that dismissal. Rather, it means that you'll go through a process that may be shorter than a normal performance management process if the employee is not performing. So there are different clauses. So make sure that if you think you've got a 90-day trial clause, that it is a 90-day trial clause. So that's what we're talking. You've got 90 days in which they can be dismissed and they can't raise that personal grievance. So hopefully that has all made sense to everyone. All right. So the different types of employment. Sometimes when we're talking to people, you hear this conversation of, look, are you part-time? Are you full-time? That is, and it's not a classification in employment law. There are three types of employment. There is permanent, that is an ongoing expectation of work. It's not going to end, okay? And we can talk about terminating employment later on, but ongoing. There is casual. What casual means, and I've got a, so here we go. Casual employment is where there is no ongoing expectation of work. So how I describe that to most clients when I'm having this conversation, whether that's an employee or employer, is that you go, do you know what? I need someone to work on Friday. You pick up the phone and say, Jim, can you come in on Friday? Jim says, nah, can't be bothered. It's meant to be cold. I don't want to go outside in the cold and I won't work today. And that's it. There's no obligation on him to accept that work. Similarly, if Jim picks up the phone and goes, hey, I was wondering, I don't want to pay to run my heat pump at home, but I'll come and sit in the office. Can I come and man the front desk for you on Friday? And you go, no, actually, we don't need you this Friday, Jim. So there's no ongoing expectation of work. The big thing with casual employees is that we want to make sure we're aware of is that they can be paid their holiday pay as they go. So in their weekly pay is an 8% top up, but there are certain requirements that need to be met. And most importantly, this needs to be set out in their employment agreement. This matters because if you get it wrong and an employee was to take a grievance further down the track or raise issue with this, an employee can end up getting their holiday pay again. The onus is on the employer to get it right. So it's worthwhile digging out those casual contracts. Make sure that you've got a clause in there around the 8% pay as you go that says you're going to be paid your holiday pay as you go. Depending on how much they're working and how long they stay an employee for, it may be a situation where they lose the ability to be paid their holiday pay as you go. And what can happen with a casual employee, using the mysterious Jim as our example, is that Jim rings up and says, hey, can I work Friday? And you go, okay, yep, no, actually, that'll work quite well. In 6 months' time, turns out Jim works every Friday. and Jim just starts showing up on a Friday because that's his day of work, instead of that phone call, that exchange around whether he needs to come in. In that scenario, he has changed from a casual employee to a permanent employee, just working on a Friday. So in that scenario, he's not going to be, if that's an ongoing role, there's not going to be the ability to pay out his holiday pay as he goes. And if you terminate him, as you would with a casual employee, you're going to be exposing yourself to a whole bunch of risk. So it's worthwhile taking your time, checking in and saying, hey, look, are these employees a true casual employee or not? Because that's what we see that people get caught out with from time to time. The classic example of an employee that's casual is the person that comes in only for sick cover, or when someone's on leave and they don't come in outside of that. So they might work one day this week, they might not work for another 3 weeks, then they work 2 days because someone else is away, and that sort of thing. It's a really ad hoc basis. All right, a fixed term employee is the last class of employee. So that is someone that is employed for either a project or a period of time. So the classic examples that we see most commonly for that is parental leave cover. So, the parents away for 6 to 12 months and you get someone in to replace them in the business. Or you might have a specific project. So looking at Canterbury, we're going through the wonderful process of changing our practice management software. And we might go, well, we need someone in here for 2 months to help with that transition. That's a specific project that we have, and they can come in and assist with that. The other one that we see from time to time is, students back for their holidays over the summer peaks, or fruit picking, all those sorts of things that are a seasonal role. That's fine. We need to say that that's the fixed term. This is the dates for which they're employed, and that their employment will come to an end at the end of that period. You can't have, as I've just put in my slides there, you can't have that it's a fixed term because of their visa requirements. That's not a valid reason to have a fixed term. Rather, it needs to be linked to your business as opposed to the employee. So that's what you want to say. The one that we see people get caught out with quite a lot, and this is with casual employees to a lesser extent as well, is that you have people that are here. You go, look, I'll employ you for a month, and if you work out then you can have a full-time job. That's not a valid reason for fixed term employment. What we can have is situations where an employee you go, well, look, there's a seasonal job here for you, and we'll see what happens after that. But you want to make sure that there's no promise of that ongoing expectation of work. Depending on the length of that fixed term project, so if it's going to be, say, 18 months, you're going to be over 12 months, so you can't pay your holiday pay as you go. But for lesser periods, you can pay them their holiday pay as you go. Once again, that needs to be included in the employment agreement, so there is no dispute. Just had a question. So how long does it take to go from a casual to a part-time? So I want to give a real classic lawyer's answer to this one. There's no magic time frame where you've gone over and there's that ongoing expectation of work. Like, oh, you've worked the last 4 Fridays. Because that could have happened completely organically. So it's one of those things that if you're not sure, you're better to err on the side of caution and have a look and see what happens. The best example is if someone is showing up to work, or they just are assuming that they're working every Friday, then that is a great example of someone moving from a casual to a fixed term. Or you look back and over the last 6 months, they've worked 15 hours every week. And they go, well, or are they grumbling about not getting enough hours? In that scenario, that seems to say that the expectation of work is shifting from that truly casual arrangement. And some great questions. So I like questions, so we're going to keep going. So with employees on a work visa, what contract would you give them? So if it's a permanent, well, it would be a permanent role, I would have them on that. It's a key requirement for them that they're able to work. So if their visa was to lapse, then that would be you would go through a process then to terminate their employment because they can't work without the valid visa. And another good question here. So can a fixed term contract be tied to a contract you have for your organization? And that's a great example of a valid reason for a fixed term contract. What can happen over time, though, and we've seen some case law on this, especially for the sort of volunteer organizations or organizations that rely on external funders, whether that's pub charity or, say, contracts from the government, is that you can only roll that over so long before it shifts from being a true fixed term. So at one extreme example, if someone has been running on a 10 years of 1 year contracts, because that's how the funding runs roll through, it's not really a fixed term agreement anymore. But you might say, we've got a contract here that runs for the next 6 months. There's your fixed term, you're hired on that. The more repetitions we go through, there's that ongoing expectation of work again, and that can make it a bit more problematic. And in that scenario, what you would do is, if you were to lose that contract, say it was 6 months and it rolled over repeatedly, then it stops, that would be when you look to go through a restructure type or a redundancy type scenario. Just because I'm talking to myself, I'm very lucky I had a drink earlier because I poured water down my shirt about 10 minutes before the start of this webinar. So another question just on probation periods. Can you extend them? So yes, you can. So a probation period, you can extend the period for, but the 90 days you can't. So that's not uncommon to see probation periods go, you might have it, say, for example, a 6-month probation period set out in the employment agreement, and you could say, well, it's not quite working, we're going to extend that. And the performance process fits in nicely with that as well, the PIP plan. Whereas a 90-day trial limit is really clear, it can only be 90 days. So it's an outcome that you can have under probation periods that gets extended. So permanent employees, as I said, these are the ones with ongoing expectations of work. It doesn't need to be set absolutely in stone, but there is a requirement for just making sure I have my minimum wage rates right. But I can't multitask. This is quite clear. But anyway, for the hours, we need to set what the minimum entitlements are. So the classic that you might do is say, well, there is going to be a minimum of 20 hours per week. And you might want to give some, depending on your business needs. So Timpany Walton, where 8:30 to 5:30, Monday to Friday, there's not a huge amount of flexibility. But if you've got a service business that might be more of a 24/7 operation or hospo, you've got a huge amount of variation there. And so what you want to do is you need to set the hours in which you could make that offer of employment. So if you're hiring someone and it's really important that they work weekends, you might say, well, I can give you a minimum of 20 hours, but that might be between Monday and Sunday. And you might have a business that starts work at 6 a.m. in the morning and goes to 9 p.m. at night. And you can say, well, there'll be 20 hours during that entire range. And within that, you might say, this week you've got a Saturday shift, next week there's a Monday shift, etc., etc. If the employee says, oh, no, I can't work Saturdays anymore, then that's your response to why we can't give you your minimum hours anymore, if that's a key part as to how those hours are calculated. You do need to set your minimum hours. If you want to be able to go to an employer, you're going through a disciplinary process because you're not working the hours that you are contracted to. You can't require an employee to work hours over and above that unless there's what we call an availability provision, which is where you say part of your wage or salary includes an allowance to be available for all work, and you have to accept that. In reality, though, what I see for businesses locally is that if an employee says, I'm not going to work on Thursday, that's not the end of the world, because if they've got something on or they need to be home because they're looking after the kids, etc., most employers don't die on that hill, and they're not saying, well, we'll get rid of you and we'll get someone else that can, because you can't treat them adversely for turning down that work. One of the things just for your permanent employees I've put there is just around your minimum wage. The employees on a salary are the ones we've really got to watch out for. And what I've been involved in cases previously where someone had a bit of a buffer or was being paid, say, just above the minimum wage. But what happened is they started coming into work half an hour earlier, or they were working through their lunch break, etc., etc. All of a sudden, instead of doing a 40-hour week, they are now doing, say, 50 hours. Now that's going to blow your minimum wage calculations right out of the water if you're really close to that threshold. So it's just being aware of the hours that they're doing and making sure that we're saying, no, hold on, you don't need to come in early. We don't want you coming in early. We're not paying you to come in early because that's not part of your role. Otherwise, you can get caught out there. The other things is we have, if you're a business that takes on apprentices or you've got a starting out wage, there's those, I've set them out there that we can just talk about. So training wage over 20, required to complete 60 credits of industry training a year, and that needs to be included in your employment agreement. Most apprentices now have an apprentice agreement with their training provider as well that sets out that requirement, and there's the requirements for a starting out wage as well. All right, the real fun and exciting stuff and positive ray of sunshine things for a Wednesday lunchtime. What is a personal grievance? So a personal grievance is a breach of your obligations as an employer. I've set out the big ones there. The main ones that we talk about and we deal with are unjustified dismissal or unjustified actions. So dismissal involves the employment coming to an end, obviously, and whether that's constructive or I came from the employer or it was actually the employer dismissing them themselves, or unjustified actions. So you've done something you shouldn't have. The big thing for personal grievances is how expensive they can get. So there is an ability to seek reinstatement. I don't see that too often here in South Canterbury. The cases that we see reported on that, the classic example is with DHBs, and working through that where they go, hey, look, this is a really amazing role. I can't just go and get another role here. I want to be reinstated into that role while we work through a personal grievance process or employment relations process. And that's what comes through. All right. So reimbursement for lost wages for up to 3 months. There's an obligation on employees to go through and look for work if they are terminated. They can't just sit back and go, I'm on holiday and I'll get my old employer to pay for this. The big one, though, that we talk about is compensation. So band 1 is up to $12,000. That's for a low-level grievance. Band 2 is 12 to 50. That's where most grievances sit. For $50,000 plus, the cases on that are really limited, and it involves some really major impact on employees, sort of situations where the leading case on that is where over a number of years, what was a really high-performing CEO, general manager role, essentially was bullied and treated by his employer in such a way that he ended up having a mental breakdown and going through periods of suicidal thoughts and those sorts of things. So a really major impact on them. And then if it goes all the way to the authority, there's a contribution towards legal costs as well. Right. So an employee has 90 days to raise a personal grievance. When we receive these, it will often include a request for copy of the wage and time records, copy of the employment agreement, and the employee file. If you can't resolve that directly with the employee or with their advocate, then it will likely head to mediation. I don't know what the percentage is, but the vast majority do resolve at mediation. And one of the reasons or the main reasons for that in my mind is the amount being sought if it goes further versus the costs involved mean that it's not that cost effective for either person to litigate and take through to the Employment Relations Authority. Most people want it sorted. There's a delay now, I think, for almost a couple of months at least to get a mediation date. If you were applying today, you wouldn't get a hearing in the Employment Relations Authority this year. So by that point, people want to move on and get to the next chapter of their life. and they don't want it to be public is the other thing. So Employment Relations Authority, it's all public. It's a classic article in the Timaru Herald and lots of other newspapers, especially if there's something interesting or scandalous that's happened. And all the details are in a judgment. So it's pretty easy reporting, and we see those articles from time to time. If the numbers are big, it makes an even more interesting headline that'll get some more clickbait. So that's always appealing to the reporters. And we see the numbers blow out really quickly if you're dealing with those lost wages claims, because if you imagine 3 months' salary for some people is a substantial sum of money and can add up really quickly. When I'm talking to people about grievances, both employers and employees, I often talk about the hitting costs there. And it's the distraction, it's the stress of having this hang over your head. And for businesses, it's taking your eye off the ball and going, for the hours that you spend getting information to provide it to the lawyers, or having these meetings, or going to a mediation, what could you be doing with that time that's actually positive for your business? And for employees, it's that same thing. If you've been through a bad experience, you're having to relive that every 6 weeks when a letter, exchange of letters or those sorts of things. We just need to be conscious of that. So I'll just give a bit of a rundown for an unjustified dismissal. So for a dismissal to be justified, it needs to be substantially justified and procedurally fair. If either of those fall over, then it's a successful personal grievance. So what that means is that the decision to fire or terminate an employee has to be justified. It's what a fair and reasonable employer would have done in that situation. And you need to have followed the right process. And you need to be able to prove that you followed the right process. So for lots of employers, it's normally face-to-face conversations. Hey, how's it going? This is what's happening. Hey, this happened. What do you say about that? Then all that happens further down the track is that you are saying, oh, no, that didn't happen that way. Or I said this to them and they said, no, you didn't. I didn't realize I was going to lose my job. And that's why we put it in writing. So this gets a bit heavy, so I'll fly through this, but the information is there on the side. So to start a dismissal process, or a poor performance or whatever it's going to be, they need to be fully informed of what those issues are. So we're going to write to the letter. We're going to say, this is a meeting to talk about ABC. They're going to be given details of any witness statements, all those sorts of things, so they can respond to them. They're told that they can have a support person. They're given a reasonable time to prepare, so they're not given a letter and 5 minutes said, now at 13 minutes to 1, saying there's a meeting at 1 o'clock. You're going to warn them of the consequences. So what's the potential outcome? Is it dismissal, a final warning? And you might refer to any other disciplinary action they've had. So, hey, the final outcome here is potentially dismissal, and it's potential because we haven't made up our mind yet. But you're also going to refer to the fact that you've had previous warnings for the same behaviour on this date, and this date. The big thing to remember is that it's the same process for a dismissal as it is for a warning. There's no requirement to go through 3 verbal warnings, then a written warning, then a final written warning. It depends on the behaviour. One of my bizarre pet hates is the sort of referring to something as a verbal warning and a written warning. They're just warnings. We write down a verbal warning anyway. It's a stupid definition, and it bothers me an irrational amount. When we're doing our investigation into misconduct, just moving on through the process, we need to get as much information in writing as we can, try and get witness statements or photographs if they're relevant. The big thing is that you can't rely on any information that you didn't have at the time you were making a decision to justify a decision after the fact. So it's worthwhile to take your time to get the investigation done right and talk to the people that you need to. For example, you couldn't say, if an employee comes at you afterwards and says, hey, that grievance was unjustified, or that dismissal was unjustified, that's not fair. You can't then go, yeah, but a month after the fact, I found out you've been stealing stuff from me. If you didn't know that at the time, you can't rely on it to justify your decision. So we've done the investigation. We're now going into the meeting and going through the employee and giving them the opportunity to respond. The big thing is the decision maker must be present. So if you're, say, in an HR role and that's your job and you run these processes, who's the one that actually makes the decision around whether it's misconduct or what the outcome is? If it's someone else, they need to be sitting in the meeting to say, this is what I've decided the outcome is. Because in that meeting, you might have to make assessments of credibility, whether you believe them or someone else, or remorse, all those sorts of things. So they should be sitting there and being able to hear it themselves from the horse's mouth so they can make that call. You need to have an open mind. What that means is that you can ask questions, but you can't do anything that demonstrates that you're not really considering those responses. Oh, you're lying, you're just full of it, etc., etc. Right? But you can ask probing questions. So you can say, well, hold on, you're saying Jim's lying. Why would Jim say that? Or you said this and that contradicts that. You need to check whether they've got a support person and run through that. If you get your letter set up right and you've set those allegations out fully, then you can just run through those allegations really nicely, and it gives you a bit of an agenda for that. And then the last couple of things there is just whether you need to undertake any further investigation. So we see that pop up from time to time, more on issues of misconduct. So say, for example, you had some waste product that would normally be thrown out and an employee took that home. And you go, well, hold on, that's actually theft. I don't want you deciding what you take home and what you don't. And the employee goes, well, yeah, but Steve told me that I was able to do that. And you'd never spoken to Steve. You don't know anything about that. You go, all right, well, we're going to have to go and talk to Steve to see what he says around that and whether he did tell you that. And you might talk to Steve. Steve says, no, never said that. That's a load of hogwash. In that case, you're going and say, you would then go back to the and say, here's the statement from Steve. He says he never told you that, and work through that. The big thing, though, is because you're coming to this meeting with an open mind, you haven't made any decisions, and you're not sure what the outcome is going to be. You're not going to get to the end of the meeting and go, sorry, mate, tough luck, you're down the road. You're going to take time to consider that response. So don't have a pre-prepared letter with the outcome there. You want to take some time, and that's a good way to demonstrate that you're thinking about things. Have the meeting, then prepare the letter with the outcome and run through there. And you can try and include some of the feedback from the employee. If you just said, yeah, if you need to reconvene that meeting, you can. So once you've had all of that, we look at what the outcome is going to be. Big thing to be aware of is consistency between other employees. So if you say you have a zero tolerance policy on drugs and alcohol in the workplace, do you have a zero tolerance policy on drugs, or is it just because you don't like that employee because they're a bit useless? Those are things that we can trip over. That's not to say that an employee that's been with you for 4 months is the same as an employee that's been with you for 10 years. You can earn some goodwill through the amount of time they've been with the business. And similarly, if they've had a number of other issues, you might say, well, this is why you're being treated differently. The big thing is if you're turning your mind to alternatives to dismissal, then that makes life a whole lot easier, because you can say, well, this is, dismissal was the last option when you have to justify your decision. Before you make a final decision, especially around something as serious as dismissal, you should really give an employee an opportunity to comment on that outcome. So you've said, look, found it's misconduct. Our potential outcome here, our proposed outcome is going to be one of dismissal. Before we make any final decision, we need some feedback from you on that. The common pitfalls that we see that pop up is Sally's witnessed something. She wants to make a complaint, but she's not prepared to put her name to it. You can't have a secret witness. The employee needs to know who's making an allegation or a comment against them, so you can respond to that. If the employee refuses to engage is another one. So you can't force them to engage, but you can still make a decision. It's just around giving them the opportunity to do so. That's another thing that pops up around criminal proceedings. Say there's theft or an assault allegation. The employee may be going through the court process and says, well, I don't want to make a statement to you because I've got a trial coming up or what have you. In that case, you can still make a decision, but they're entirely separate. You can't say, well, if you resign, I'm not going to go to the police. That's the definition of blackmail. One of the things that I am a big fan of is recording every meeting just on your phone. Most of them have a voice recorder on them. And for those of you that have sat through a meeting with me will know that my handwriting is absolutely atrocious. What it just means is that generally it can help keep everyone's behavior in check, but you just put the phone out in the middle and just say, look, so we can talk naturally, I'm just going to record this conversation, and then I can give you a copy if you need it, and we can refer back to it if we need. Rather than having someone there frantically trying to take notes as you go and get specific quotes and those sorts of things, it can be quite tough. All right. The last thing I've got to talk about as we're flying through is just leave. This is what I talk about being horrible. Holidays Act is a horrific piece of legislation. So those are the four main types of leave. Annual leave, so you need 12 months continuous employment. You can't unreasonably deny leave, and an employee needs to have the ability to take at least 2 weeks leave in a continuous period. If you can't reach agreement around when leave's taken, an employee can direct that leave has to be taken on at least 14 days notice, so 2 weeks notice, and we saw that during the COVID lockdowns. And businesses can have one annual close down period per year, whether that's a Christmas break for an office job, or it might be in hospo closing down over a couple of winter months or during that period. For employees can make a request for 1 year to be paid out, 1 week, sorry, to be paid out of their annual leave, but only 1 week. And any annual leave is paid out at the end of their employment. Sick leave, the big thing there is it makes no difference whether you're working full-time or so 5 days a week, 7 days a week, or 1 day a week. It's still 10 days. And you can request a medical certificate if they have been absent for more than 3 days. That might be that they were absent on the Friday and they're absent again on the Monday. It includes the period in between. And then it's in the employee's cost. If you want a medical certificate after 1 day, you can do it, but it's at the employer's cost. My view on that is it's a waste of time, because we've all probably seen a medical certificate that just says the employee's name has been seen by me, or I've spoken to them and they are medically unfit to work. What does that tell me? It doesn't really prove anything. You can set a maximum period of leave that can be accrued, for example, 20 days or what have you. And it does give the employee can use that to care for other people. So cares that they're dependent, so that might be children, grandparent, what have you. And if you run out of sick leave, you can use your annual leave for that. The big thing here is around public holidays. So if it would otherwise be a working day, they're paid. This is where the Holidays Act is rubbish, because how do you establish a pattern? And so what we can generally look at is look over the last 4 to 6 weeks and see whether they've been consistently working during that period. So I'm just flying through. There is a question here. If you have a person on a 12-month fixed term, could you extend them for another 12 months to assess medium long-term sustainability for the role? So the short answer is not really. With the lawyer's caveat there of get out of jail free, but they need to be there for a project. And so if you're uncertain, then you would roll it over and say this is what it is. But the risk becomes as you roll over more than once. So the more times you do it, the more problematic it's going to do. And another question here, can employees still bring proceedings against employers even after a confidential settlement is made through MB for matters that were not known to the employees at the time of the settlement? It depends on what the wording is of the record of settlement. Sometimes they're in full and final settlement of all claims, in which case you wouldn't be able to go back and make that claim. The challenge would be for the employee to be able to, I'm just trying to think of circumstances where they wouldn't be aware of something that would give rise to a personal grievance. Yeah, that's a tough one there, but there may be circumstances. One of the things that would be if the employer has provided false or misleading information, potentially to get them into that record of settlement. All right, so just before everyone disappears, we are running sort of Ask Me Anything panel with through the chamber coming up later this year, and we'd just love some feedback from you as to what time of day would suit you best. This would be an in-person session. Whether we run something in the morning, which, not being a morning person, I am slightly biased as to not being top of my list, or whether a lunchtime or an after work session. If you could just have a click on that and say what would suit you the most, as we want to try and put something like this on at a time when everyone can attend. And the last thing is, if you do need any help with your employment law, whether that's employment agreements, investigations, responding to personal grievances, please reach out to me or my team here. We'd love to help you. And it's easier to have that phone call at the start rather than at the end of the process, because it can make it a whole lot more streamlined and a whole lot less stressful. Thank you very much. I'm going to pass it back.
Thank you so much, Tom. Look, we really appreciate your clear and practical guidance on what we've heard today. So thank you. Just a quick last few notes from me. So we've got a few upcoming trainings. On the 17th of June, we've got Developing People Skills. On the 24th of June, Health and Safety from a Management Perspective. And on the 25th and 26th, a 2-day course on Health and Safety Stage 1. So thank you all for joining us today for this insightful session. We look forward to seeing you at our next Lunch and Learn, which stay tuned into our events and training. If you're not signed up for that newsletter that comes out bi-weekly, flick myself an email and I'll pop you on that. And we look forward to seeing you at the next one. Until then, take care and stay warm. Bye, everyone.